Natural rights are central to understanding the gun debate in America. The founders established the United States on the belief that these rights are inherent to all people, existing independently of any government. The Declaration of Independence, the Constitution, and the Bill of Rights do not create rights. They recognize and protect them. These natural rights remain valid even if a law, such as the Second Amendment, is altered or repealed, which is why many would refuse to surrender their firearms regardless of legal changes. Natural rights are a result of natural law. George Mason's assertion highlights the supremacy of natural rights over government power.
All acts of legislature apparently contrary to natural right and justice are considered as void.
Natural rights and natural law are often spoken of interchangeably, though they refer to related but distinct concepts. Natural law represents the universal moral principles that exist regardless of government or societal laws, while natural rights are the specific entitlements derived from those principles. Both ideas assert that these rights are inherent to human beings and exist independently of government recognition. Natural law is rooted in the nature of humanity and represents moral truths that apply universally. According to its traditional definition, natural law is a philosophy asserting that certain rights are inherent by virtue of human nature, endowed by nature, traditionally by God or a transcendent source, and that these can be understood universally through human reason. This understanding forms the bedrock of American constitutional thought, which recognizes that rights exist prior to and independent of any government. Natural law theorists in the founding of America. To understand the connection between natural rights and the founding of America, it's essential to look at the philosophers who influenced the founders. Thomas Jefferson, in a letter to Henry Lee, articulated how the Declaration of Independence drew from well-established principles rather than introducing new ideas.
When forced, therefore, to resort to arms for redress, an appeal to the tribunal of the world was deemed proper for our justification. This was the object of the Declaration of Independence, not to find out new principles or new arguments never before thought of, not merely to say things which had never been said before, but to place before mankind the common sense of the subject. Terms so plain and firm as to command their assent and to justify ourselves in the independent stand we compelled to take, neither aiming at originality of principle or sentiment, nor yet copied from any particular and previous writing. It was intended to be an expression of the American mind, and to give to that expression the proper tone and spirit called for by the occasion. All its authority rests then on the harmonizing sentiments of the day, whether expressed in conversations, in letters, printed essays, or in the elementary books of public right, as Aristotle, Cicero, Locke, Sidney, etc.
Aristotle, 384–322 BC, one of the earliest proponents of natural law, wrote,
"Universal law is the law of nature, for there really is, as everyone to some extent divines, a natural justice and injustice that is binding on all men, even on those who have no association or covenant with each other."
Cicero, 106–43 BC, another significant influence on American political thought, emphasized,
"Law in the proper sense is right reason in harmony with nature."
He stressed the universality of this law.
"There will not be one such law in Rome and another in Athens, one now and another in the future, but all peoples at all times will be embraced by a single and eternal, unchangeable law."
Cicero also spoke of the natural right to self-preservation, a core element of the right to self-defense.
First of all, nature has endowed every species of living creature with the instinct of self-preservation, of avoiding what seems likely to cause injury to life or limb, and of procuring and providing everything needful for life, food, shelter, and the like.
John Adams held Cicero in high regard, stating,
"All the ages of the world have not produced a greater statesman and philosopher united in the same character. His authority should have great weight."
Thomas Aquinas, 1225 and 1274, expanded on the idea that natural law is connected to divine law, stating,
"The natural law is nothing else than the rational creature's participation of the eternal law.
Aquinas further elaborated,
By nature, all men are equal in liberty, but not in other endowments.
Algernon Sidney, 1622 and 1683, whose writings inspired revolutions in both England and America, declared,
That which is not just is not law, and that which is not law ought not to be obeyed.
Thomas Jefferson recognized Sidney's contributions, placing him alongside Locke as one of the central influences on the American understanding of liberty.
Resolved that it is the opinion of this board that as to the general principles of liberty and the rights of man in nature and in society, the doctrines of Locke, in his Essay Concerning the True Original Extent and End of Civil Government, and of Sidney in his Discourses on Government, may be considered as those generally approved by our fellow citizens of this and the United States.
John Locke, the philosopher of natural rights. John Locke, 1632–1704, profoundly influenced the American Revolution with his writings on natural rights. Locke argued that life, liberty, and property are inherent rights, existing in a state of nature before the formation of government. He famously wrote,
Men being by nature all free, equal, and independent, no one can be put out of this estate and subjected to the political power of another without his own consent.
Locke's understanding of property rights was central to his philosophy.
Though the earth and all inferior creatures be common to all men, yet every man has a property in his own person. This nobody has any right to but himself.
Locke argued that governments are created to protect these natural rights, especially property.
The great and chief purpose of men's uniting into commonwealths and putting themselves under government is the preservation of their property.
A limited government was never intended to have the power to take away people's rights or dictate how they can exercise them. Locke believed that if a government oversteps its authority, the people have a natural right and a moral obligation to resist tyrannical rule.
Whenever the legislators endeavor to take away and destroy the property of the people, or to reduce them to slavery under arbitrary power, they put themselves into a state of war with the people, who are thereupon absolved from any further obedience, and are left to the common refuge which God hath provided for all men, against force and violence. Whensoever therefore the legislative shall transgress this fundamental rule of society, and either by ambition, fear, folly, or corruption, endeavor to grasp themselves, or put into the hands of any other, an absolute power over the lives, liberties, and estates of the people. By this breach of trust they forfeit the power the people had put into their hands for quite contrary ends, and it devolves to the people, who have a right to resume their original liberty.
Lysander Spooner on natural rights and resistance. Lysander Spooner, 1808–1887, a natural law proponent and legal theorist, also emphasized that resistance to oppression is a natural instinct, learned from an early age.
Children learn the fundamental principles of natural law at a very early age. Thus they very early understand that one child must not, without just cause, strike or otherwise hurt another, that one child must not assume any arbitrary control or domination over another, that one child must not, either by force, deceit, or stealth, obtain possession of anything that belongs to another, that if one child commits any of these wrongs against another, it is not only the right of the injured child to resist and, if need be, punish the wrongdoer and compel him to make reparation, but that it is also the right and the moral duty of all other children and all other persons to assist the injured party in defending his rights and redressing his wrongs. These are fundamental principles of natural law which govern the most important transactions of man with man. Yet children learn them earlier than they learn that 3 and 3 are 6, or 5 and 5 10.
Spooner's emphasis on the inherent nature of these rights underscores the fundamental principle that natural rights are self-evident and universally recognized, even by children. The natural right of self-defense and firearms. The right to self-defense is perhaps the most obvious and essential natural right. St. George Tucker highlighted this in his commentary on the laws of England.
This may be considered as the true palladium of liberty. The right of self-defense is the first law of nature. In most governments, it has been the study of rulers to confine this right within the narrowest limits possible. Wherever standing armies are kept up, and the right of the people to keep and bear arms is, under any color or pretext whatsoever, prohibited, liberty, if not already annihilated, is on the brink of destruction.
Thomas Hobbes also recognized the inherent right of self-preservation.
If a man by the terror of present death be compelled to do a fact against the law, he is totally excused, because no law can oblige a man to abandon his own preservation.
Murray Rothbard, in his work on property rights, explained the connection between self-defense and property.
If every man has the absolute right to his justly held property, it then follows that he has the right to keep that property, to defend it by violence against violent invasion. For if a man owns property and yet is denied the right to defend it against attack, then it is clear that a very important aspect of that ownership is being denied to him. To say that someone has the absolute right to a certain property but lacks the right to defend it against attack or invasion is also to say that he does not have total right to that property.
Rothbard also addressed arguments for restrictions on firearms in the context of self-defense, warning against vague or future threats being used to justify infringements on rights.
In the same way, it could be held that A, the failure to ingest vitamins makes people more irritable, that B, the failure is therefore likely to increase crime, and that therefore C, everyone should be forced to take the proper amount of vitamins daily. Once we bring in threats to person and property that are vague and future, i.e., are not overt and immediate, then all manner of tyranny becomes excusable. The only way to guard against such despotism is to keep the criterion of perceived invasion clear and immediate and overt.
Aristotle also recognized that self-defense is natural.
Now it must be wrong to say, as some do, that the structure of man is not good. In fact, that it is worse than that of any other animal. Their grounds are that man is barefoot, unclothed, and void of any weapon of force. Against this we say that all the other animals have just one method of defense and cannot change it for another. For men, on the other hand, many means of defense are available, and he can change them at any time, and above all, he can choose what weapon he will have and where.
The Dutch scholar Hugo Grotius shared a similar view.
For all animals are provided by nature with means for the very purpose of self-defense.
Cicero further articulated the natural right of self-defense, including the moral right to use arms when necessary.
There exists a law, not written down anywhere but inborn in our hearts. A law which comes to us not by training or custom or reading, but by derivation and absorption and adoption from nature itself. A law which has come to us not from theory but from practice, not by instruction but by natural intuition. I refer to the law which lays it down that, if our lives are endangered by plots of violence or armed robbers or enemies, any and every method of protecting ourselves is morally right.
Hobbes also emphasized that the right to protect oneself cannot be relinquished by any agreement or law.
For the right men have by nature to protect themselves, when none else can protect them, can by no covenant be relinquished.
The importance of self-defense and the means to do so is emphasized by numerous thinkers throughout history. Aristotle noted that
those who possess arms must be superior in power to both the other sections.
Algernon Sidney articulated the natural right of self-defense as a safeguard against tyranny.
Nay, all the laws must fall, human societies that subsist by them be dissolved, and all innocent persons be exposed to the violence of the most wicked, if men might not justly defend themselves against injustice by their own natural right, when the ways prescribed by public authority cannot be taken.
And finally, Samuel Adams in 1772 asserted the natural right of the people to defend themselves.
Among the natural rights of the colonists are these: first, a right to life; secondly, to liberty; thirdly, to property, together with the right to support and defend them in the best manner they can.
The eternal relevance of natural rights. Natural rights are not granted by governments. They exist independently of them. Governments are instituted to protect these rights, but when they fail, the people have the right to defend themselves. As Cesare Beccaria warned,
The laws that forbid the carrying of arms disarm those only who are neither inclined nor determined to commit crimes. Such laws make things worse for the assaulted and better for the assailants.
these timeless principles remain central to the ongoing debate over gun rights and government power. Join us next time as we explore the creation of the U.S. Constitution, a revolutionary document born from intense debates, state rivalries, and the desire to secure liberty against government overreach. Discover how the founders balanced federal power with state sovereignty, why the Bill of Rights was added, and how these struggles continue to shape the battle for gun rights today. Don't miss this deep dive into the Constitution's origins, meaning, and modern relevance. See you in the next episode. Please remember to like, subscribe, and share.